If you woke up this morning terrified because you saw a headline claiming that thousands of Americans are losing their citizenship right now, or if someone sent you a panic-inducing social media post saying the government is mass canceling naturalized citizens, or if you're lying awake at night wondering whether your hard-earned United States citizenship could just vanish overnight because of a rumor you read online, I need you to take a breath and stay with me for the next few minutes. Because what I'm about to share with you is the actual truth based on federal immigration law, Supreme Court precedent, and official government policy. The fear is real. The confusion is everywhere. But the facts are clear. And by the end of this video, you will know exactly what the law actually says, what can and cannot happen to your citizenship, and most importantly, why the vast majority of naturalized United States citizens have absolutely nothing to fear. My name is Timothy, and this is US Updates Hub, where we cut through the noise and deliver only verified fact-checked immigration information you can trust. Let me be very direct with you right from the start. United States citizenship, whether you were born here or you earned it through naturalization, is one of the most legally protected statuses that exists anywhere in the world. The United States Constitution, the Supreme Court, and over 2 centuries of legal precedent have established that citizenship is not something the government can just take away from you on a whim. Not because of a policy change, not because of political pressure, and certainly not because of a viral social media post. But that does not mean citizenship is absolutely untouchable in every single circumstance. There are very specific, very narrow, and extremely rare legal pathways through which United States citizenship can be lost or revoked. And understanding exactly what those pathways are, how they work, and who they actually apply to is critical if you want to separate fact from fear. The first thing you need to understand is the difference between denaturalization and loss of citizenship. These are 2 completely different legal processes. Denaturalization is when the United States government goes to federal court and asks a judge to revoke the citizenship of someone who was naturalized, meaning someone who became a citizen through the naturalization process, not someone who was born a United States citizen. Loss of citizenship, on the other hand, refers to situations where a United States citizen, whether born or naturalized, voluntarily takes an action that results in losing their citizenship. Both of these processes are governed by federal law and both are extremely rare, but they are not the same thing, and the legal standards for each are very different. Let me start with denaturalization, because this is the one that generates the most fear and the most misinformation. Denaturalization can only happen if the United States government files a lawsuit in federal court and proves to a judge that your naturalization should never have been granted in the first place because you obtained it through fraud, willful misrepresentation, or illegal conduct. This is not an administrative process. USCIS cannot just send you a letter saying your citizenship is canceled. The Department of Homeland Security must file a civil complaint in United States District Court. You have the right to legal representation. You have the right to defend yourself, and the government must prove its case with clear and convincing evidence. This is a very high legal standard, and federal judges do not take these cases lightly. Under Section 340 of the Immigration and Nationality Act, denaturalization can only be pursued if the government can demonstrate that the person procured their citizenship illegally or by willfully misrepresenting or concealing a material fact. What does that mean in plain English? It means that if you lied about something important on your naturalization application, or if you deliberately hid information that would have made you ineligible for citizenship, and the government can prove that you did this intentionally, then yes, your citizenship can be revoked through a court process. But we are not talking about minor mistakes or accidental errors. We are talking about deliberate fraud. We are talking about someone who lied about their identity, lied about serious criminal history, concealed involvement in terrorism or war crimes, or obtained citizenship while deliberately hiding facts that would have disqualified them. The Supreme Court case of Schneiderman versus United States, decided in 1943, established that denaturalization is a severe penalty and must be proven with evidence that leaves no reasonable doubt. More recently, in the 2017 case of Maslenjak versus United States, the Supreme Court unanimously ruled that the government cannot strip someone of citizenship based on an immaterial lie. The lie must have been material, meaning it must have been something that actually affected the decision to grant citizenship. If you made a mistake on your application but it did not change the outcome, that is not grounds for denaturalization. This ruling reaffirmed that the bar for taking away citizenship is intentionally very high. Now, let me give you the 5 real, legally recognized reasons why someone could lose United States citizenship. And I want you to pay very close attention to how specific and narrow these categories are because they do not apply to the overwhelming majority of naturalized citizens. Reason number 1 is obtaining naturalization through fraud or willful misrepresentation, which I just explained. This includes lying about your identity, concealing serious criminal convictions, hiding involvement in prohibited organizations like terrorist groups, or providing false testimony during your naturalization interview. If the government discovers this and can prove it in court, your citizenship can be revoked. But again, this requires a federal lawsuit, evidence, and a judge's ruling. It does not happen automatically. Reason number 2 is membership in a subversive organization within 5 years of naturalization. Under the Immigration and Nationality Act, if you become a member of an organization that advocates the overthrow of the United States government by force or violence within 5 years after you naturalize, and the government can prove that you concealed this during your application process, that can be grounds for denaturalization. This provision was designed to address national security concerns and applies to groups engaged in terrorism, espionage, or violent insurrection. This is not about political beliefs or peaceful activism. This is about active involvement in organizations seeking to harm the United States. Reason number 3 is an honorable discharge from the United States military being reversed. Some individuals naturalize through military service under special provisions that allow expedited citizenship for those serving in the armed forces. If someone naturalizes based on military service, and their honorable discharge is later changed to a dishonorable discharge due to conduct that occurred before naturalization, that can serve as a basis for denaturalization. This is a very specific situation that affects a very small number of people. Reason number 4 is voluntary relinquishment of United States citizenship. This is not the government taking your citizenship away. This is you making a deliberate formal decision to give it up. United States citizens can renounce their citizenship by appearing before a United States consular officer abroad and signing an oath of renunciation, or in some very rare cases, by taking certain actions that demonstrate an intent to relinquish citizenship, such as formally swearing allegiance to a foreign government with the intent to give up United States citizenship. But here is what is critical. You cannot accidentally lose your citizenship. The law requires that any act of relinquishment must be done voluntarily and with the specific intent to give up United States citizenship. The Supreme Court ruled in Vance v. Terrazas that intent is the key factor. Simply becoming a citizen of another country, working for a foreign government, or even voting in a foreign election does not automatically cause you to lose United States citizenship unless you do it with the intent to renounce your allegiance to the United States. Reason number 5 is denaturalization, based on refusal to testify before Congress within 10 years of naturalization. Under a rarely used provision of immigration law, if a naturalized citizen refuses to testify before a congressional committee investigating subversive activities within 10 years of naturalizing, and that refusal is based on self-incrimination grounds related to activities that would have barred naturalization, it can theoretically serve as a basis for denaturalization. This is an extremely uncommon scenario and has not been widely applied in modern immigration enforcement. Now that you know the 5 actual legal grounds for loss of citizenship, let me tell you what is not on that list, because this is where the fear-mongering and misinformation run wild. You cannot lose your United States citizenship because of a policy change. You cannot lose it because a new administration comes into office. You cannot lose it because you travel internationally. You cannot lose it because you made a minor mistake on a tax form or missed a traffic ticket. You cannot lose it because you expressed political opinions. You cannot lose it because you were once undocumented before you became a citizen through a lawful process. You cannot lose it simply because someone on social media says you can. I need to address something very important here because there has been a lot of confusion and fear surrounding recent political rhetoric and proposed policies. From time to time, political figures or advocacy groups will talk about expanding denaturalization efforts, increasing scrutiny of naturalized citizens, or reviewing past cases for fraud. When you hear this kind of language, it is absolutely essential that you understand the difference between political discussion and actual enforceable law. Unless Congress passes a new law, the president signs it, and it survives any court challenges, the legal standards for denaturalization remain exactly what I just described. Political rhetoric does not change the Constitution. It does not change Supreme Court precedent, and it does not give the government any new power to take away citizenship without going through the federal court system and meeting the same high burden of proof that has existed for decades. Yes, the Department of Justice and USCIS have the authority to investigate cases where they believe fraud occurred, and yes, they can file denaturalization lawsuits. But every single one of those cases must go before a federal judge, and the government must prove its case. In recent years, there have been efforts to increase resources for investigating naturalization fraud, particularly in cases involving identity fraud, terrorism, and war crimes. These efforts are real and they are ongoing, but they are targeted at specific cases of serious fraud, not at the general naturalized citizen population. If you went through the naturalization process honestly, answered all questions truthfully, disclosed everything you were required to disclose, and obtained your citizenship lawfully, you have nothing to fear from these enforcement efforts. Let me also clarify something about the scrutiny of naturalization applications. USCIS does conduct background checks, interviews, and reviews of every single naturalization application. That is part of the process. Sometimes USCIS will issue a request for evidence or schedule a second interview if something in your file needs clarification. This is normal. This does not mean they are trying to denaturalize you. It means they are doing their job to verify that your application is complete and accurate. If you receive any kind of notice or request from USCIS regarding your citizenship application or status, do not panic and do not ignore it. Respond promptly. Provide the information requested, and if you are unsure about how to respond, consult with a licensed immigration attorney who can review your specific situation. For those of you who are green card holders watching this and wondering whether you should be worried about applying for naturalization because of denaturalization fears, let me be very clear. If you are eligible for naturalization, if you meet all the requirements, if you have been a lawful permanent resident for the required period, if you have good moral character, and if you can answer all the questions on the N-400 application truthfully and accurately, you should not be afraid to apply. Naturalization is a legal right for those who qualify, and United States citizenship provides benefits and protections that permanent residency does not. The key is to be honest, thorough, and accurate in your application. Do not hide anything. Do not misrepresent anything. And if you have any issues in your past, such as arrests, immigration violations, or time spent outside the United States, disclose them and explain them. An immigration attorney can help you understand how those issues might affect your case and how to present them properly. Now, let me address what you should do if you are a naturalized citizen and you are genuinely concerned about your status. First, if you obtained your citizenship lawfully and honestly, you do not need to do anything. Your citizenship is secure. You do not need to reapply, re-register, or prove anything unless the government formally contacts you with a legal notice. Second, if you know that you made a mistake or omission on your naturalization application, or if you are contacted by USCIS or the Department of Justice regarding your citizenship, do not try to handle it alone. Contact an experienced immigration attorney immediately. Denaturalization cases are complex. They involve federal litigation, and you need professional legal representation. Third, keep records of your naturalization process, including your naturalization certificate, any correspondence with USCIS, and evidence that supports the truthfulness of your application. These documents can be helpful if any questions ever arise. I also want to address the emotional and psychological impact of this kind of fear. For many naturalized citizens, the idea that the country you worked so hard to join, the country you swore allegiance to, could take that away from you is deeply disturbing. I understand that, but I need you to remember that the legal protections around citizenship exist precisely because our system recognizes how precious and important that status is. The courts, the Constitution, and the law are on your side as long as you obtained your citizenship lawfully. You are not second-class citizens. You have the same rights, the same protections, and the same constitutional guarantees as anyone who was born here. If you're watching this video because you saw a sensational headline or a viral post claiming mass denaturalization is happening, I want you to verify that information. Go to official sources. Check USCIS.gov. Check the Department of Justice website. Look for actual court filings, actual policy memos, actual Federal Register notices. Do not rely on screenshots, anonymous posts, or fear-based content designed to get clicks and views. Immigration law is public. It is documented. It is verifiable. And when real changes happen, they are announced through official channels. Let me be very clear about one final thing. The information I have shared with you today is general educational information based on current United States immigration law and policy. It is not personal legal advice, and it does not create an attorney-client relationship. Every immigration case is different, and if you have specific concerns about your citizenship, your status, or any legal matter, you should consult with a licensed immigration attorney who can review your individual circumstances and provide advice tailored to your situation. Do not make legal decisions based solely on a YouTube video, no matter how well researched it is. So, where does this leave us? United States citizenship is one of the most secure and protected legal statuses in the world. It can only be taken away through very specific, very narrow legal processes that require court involvement, evidence, and proof of serious fraud or illegal conduct. If you became a citizen honestly and lawfully, your status is safe. The fear you see online, the panic-inducing headlines, the rumors about mass denaturalization, they are not supported by the law or by what is actually happening in the immigration system today. Yes, the government has the authority to pursue denaturalization in cases of fraud. Yes, they are investigating certain cases, but no, there is not a wave of citizenship cancellations targeting ordinary naturalized citizens who followed the rules. If this video gave you clarity, if it helped you understand the actual law instead of the fear, I need you to do something for me. Subscribe to US Updates Hub right now so you never miss fact-based, verified immigration news. Share this video with anyone you know who is worried about their citizenship or who has seen misinformation about denaturalization. And leave a comment below if you have questions or if there are other immigration topics you want me to explain with the same level of detail and accuracy. We are building a community here that values truth over panic, facts over rumors, and real information over clickbait. Thank you for watching. Thank you for trusting this channel, and I will see you in the next one.